Morning, Mr. Gonzalez. Do you speak English?
Yes.
Morning.
Morning.
You're charged with two cases. You're charged with evading arrest and resisting arrest, facing up to a year in jail and or a $4,000 fine in both of these cases. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 22nd, 2025, at around 7 p.m., officers were dispatched to 1855 Work Road in Houston, Harris County, Texas, in regards to a criminal mischief in progress. Upon arrival, the officers observed the defendant at a location matching the description of the false slip. The officer gave verbal commands for the defendant to lay on the ground and put his hands behind his back. The defendant ignored commands and ran away from the officers. A foot pursuit was initiated, and the officers continued to yell verbal commands for the defendant to stop running. The officers were able to detain the defendant approximately 100 meters away. The defendant then actively resisted, and the officers had to dry stun him. The defendant was using both hands to push off officers in order to avoid containment. The defendant grabbed the officer's ballistic vest and attempted to push the other officer. The defendant attempted to push officers multiple times, and the defendant struggled on the ground for approximately 3 minutes.
What was he doing wrong? Oh, you said he matched a call slip. So?
Yes, for a criminal mischief. Sure.
That's completely conclusory. What is the alleged mischief? What did he do wrong? Who did he do wrong to?
And I don't have that information.
Yeah. None of it? I mean, who's writing the reports? Mickey Mouse? You know? I mean, really? I remember that. I'm gonna find no probable cause. Mr. Gonzalez, be careful, man. Okay. When you get into a pissing match with people who have the power of us, who's gonna win?
I'm gonna be more careful. I promise. It's not gonna happen anymore. I promise. I got my family. I want to, Okay. Thank you. God bless you.
All right. Good morning, Mr. Walker. So, with us, you were charged with failure to identify oneself. That's why you're charged here with us, failure to ID, right? You're facing up to 6 months in jail and or a $2,000 fine. The reason that we're taking you into custody now is because you have 2 felony warrants for, it looks like you were on probation for felony theft. And they filed, I guess, a motion to revoke because of that warrants issued. So that's why we have you in custody now. Can't let you go, because then I would get in trouble. We're going to do probable cause in our case. You have the right to remain silent. Anything you say can or will be used against you. Well, I don't want to talk about the case. You've got a lawyer. You know, you need to talk to him, let him talk to me, because I don't want you to say something that's anymore. So let's just do probable cause, because I don't know why. I don't even know why we're here. Hold on, let's do probable cause first. Yeah, I can't, there's nothing I can do on the felony case, man. I'm just in this lowly misdemeanor.
Just question. So the only motion is based on children. This case, the studio ID.
Really?
Yeah, I don't see anything.
Well, let's do it real quick, and then we can talk, and I can give you more info.
On March 23rd, 2025, officers were dispatched to a family disturbance call for service at 2525 Bullsworth Road in Spring, Harris County, Texas, which is an apartment complex. The officer began by identifying the defendant, who could not provide a valid driver's license. The defendant verbally identified himself as Adam Mitchell with the date of birth December 23rd, 1987. The reporting then gave the officers his correct name, and the defendant then admitted to providing false information due to advising about a traffic warrant that he believed he had. The defendant then gave his correct name. The officers discovered an active warrant for the defendant at Cook County, though there was no execution.
So there was a warrant out of Cook County.
There was no execution.
She always wanted the name is essentially like John Owens.
Okay.
That was
Nice voice. So he gives the name of Adam.
Adam Mitchell. And then this isn't filed as a fugitive. Yes, ID.
Well, because he was. Well, maybe he was. I don't know. Regardless, so Mr. Walker, I'm going to find that there's sufficient probable cause. Hold on. I'm going to find that there's sufficient probable cause to go forward in this failure to ID case. It looks like.
Call the police. I don't want to call the police. They never asked my name.
I don't.
Like, I'm the person who called the police.
Jesus, I thought it was.
No, they
No.
were dispatched to a family disturbance at an apartment complex. The officer arrives, proceeds to try to identify both individuals. Began by identifying the defendant, who did not provide a valid driver's license, and then identified himself verbally as Adam Mitchell with the date of birth of December 24th, 2015.
I mean, get a call, but nevertheless, I mean, we've got.
Who told me what?
We still gave the wrong info, and then they looked them up, and then they did, you know? So, I mean, there's enough probable cause to go forward.
That didn't happen. Like, why did, like, if I call the police, why are they asking for my ID in the first place? They don't have the right to do that, son.
They're going there for disturbance.
Yeah,
They
because
have to, look, I can't get into that, all that stuff now. But they're going to investigate something that happened. It's a disturbance. They go there. Normally what officers do is they have to look at everybody who's there to determine, hey, who is this? What's going on here? Does this person have any kind of issues? And so, you know, regardless, the good news is that it looks like on your motion to revoke, the only thing is fee that I see in this case. Okay? I can't let you go at this time because this is a felony. You're set at no bond now, but you'll get to felony court on Monday, and at that point, you know, I'm sure that they'll do something. I'm not gonna, you know.
That's crazy, bro. Call the police.
I'm not gonna.
We'll fight it. I just called the police. That's all I did, son. I said, two was flying, and I called the police because there's a guy in the water.
I can't hold you legally.
Yes. She's right there.
Don't say anything. You talk to Mr. Pons. I'm not putting any conditions on your bond. Just be careful. Just don't. Okay, thanks.
What was our this one? PR?
Yeah, he's got a PR.
That's right. No, she reached out.
Excuse me, Your Honor, I'm approaching on Neil White. And Judge, he's been carried like since Monday, the 24th. That's when he appeared on your docket initially for a new charge for the bond violation report, filed, and also a motion to revoke and raise. But he was still incarcerated on Monday, Judge. Monday morning.
He's right here now, right?
He's here now.
Okay.
But,
Mr. White,
Mr. White.
on bond for an assault of a family member.
Yes, sir.
2023.
Yes, sir.
2025, in February, you picked up a terroristic threat, and now you've picked up another assault of a family member in a violation of protective orders. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. You're not a court one. One will be appointed.
On May 16, 2025, in Houston, Texas, spoke to the dispatch to an apartment for family assault. Mr. Miller, the planned witness. Planned witness had small injuries on her face, including bruising on her eye and swelling her. Planned witness went over to the defendant's house, the defendant grabbed the planned witness by the arms and threw her into a table and chairs. The began to punch the planned witness multiple times to the stomach and slapped her in the face. The planned witness attempted to leave, but the defendant followed him through the apartment. The defendant currently has a protective order for terrorist threat as far as contacting the planned witness.
The violation of protective order?
Yeah, that's how I
Your Honor, may I be heard? Your Honor, the complaining witness shows up at my client's apartment. He lives there by himself. She shows up like at 5 a.m. in the morning. My client did not assault her in any way. I actually, the complaining witness broke his phone, and my client left the apartment so he wouldn't have to to deal with her because she wouldn't go away. But at no time, Your Honor, did he assault her. I did get to check out videos, Your Honor, where the officers are interviewing the complaining witness. She alleges that he punched her in the abdomen. She is in absolutely no distress, Your Honor, when she's talking to the responding deputies. If she had punched her in the abdomen, Your Honor, I can really say that she probably would be doubled over and would want to go to the hospital. The EMS did check her out, Pierce, but she refused transport to the hospital. I couldn't tell from the body-worn cam video, Judge. It wasn't close up enough, but I couldn't tell. I couldn't see any bruises, or it's like I said, she was not in distress whatsoever. She is the one who really went to his apartment. He did not go. He did not violate the protective order, and
Violation of protective order is a felony offense anyways, so.
yes, Judge. Yes, Judge. I understand. I understand.
So, I just have, an assault, terrorist threat, now another assault.
Right.
So which assault is he alleging that's the?
No, Judge.
Right.
Please, Judge. And she's filed or the state has filed a terroristic threat on her behalf, a charge on her behalf. If she was so terrified of him, Judge, why is she popping up at his
I
apartment?
don't think that's actually true. You said he's just telling that to you? I mean, how do we know it's really true?
Well, she's there, Judge. Those are the apartments that are shown on the body-worn cam video. It's his residence.
I'm actually on video at his apartment. Have you
They're
seen it?
outside of the apartment. They're outside on FM 1960. That is not a residence. The protective order has got a totally different address where he is prohibited from going.
Okay, well, the DPO is not based on address restriction, it's based on the assault of the type of person. And as far as the representations that defense made today, with no way verifying any of that to be true, I disagree with the assertion that she shows no physical injuries. Face does appear to be swollen with some red markings. Number three, the allegation that she's over at the house disqualifying her as a protected individual, and DPO is going to not their residency restriction. And at the end of the day, all those are fact issues. What we're left with right now is the fact that in 2023, with a separate victim, he has an AFM, he law enforcement. Then we have a terrorist attack with someone else. Now he picks up a separate AFM. And we can talk about what she's found all the time, because it ignores, first of all, the realities of domestic violence situations. And second of all, this isn't just one person that he's having multiple problems with, it's two separate people. So the state is going to stand on its motion to revoke and raise bail is going to have to $20,000 for gifts.
Your Honor, may I respond? The complaining witness has not, recanted to these March 16th to the current charges, to the newer charges.
Which alleged victim is recounting, the first or the second?
The terroristic threat complaining witness, Your Honor. And the other assault family member case, Judge, the complaining witness is currently incarcerated. But
So which one?
Yeah, I'm on this one. Yeah.
and
Or
No, I'm not sure, actually. I had a colleague who spoke correctly, which is yeah. As far as her recanting, that's
is she in jail for something against him?
no, I don't think so.
And also, Judge, the complaining witness, the one that the order is on behalf of, she has not given a rip on the terroristic threat case, Judge. So something's not right. She doesn't want to.
Problem is
So
he keeps picking up cases. Stuff keeps happening to him. It's just, I mean, I fall down and I pick up a new case.
Yes, Judge, and I did
And
not.
are we supposed to just let him go because he's now a felon? You know?
I just wanted to relate to you, Your Honor, that my client does not have funds. He paid to get out with his income tax return, Your Honor. He paid to get out on these two new charges. He paid to get his car because he was not arrested at the scene, but he was arrested thereafter while he was driving. They impounded his car. He paid to get his car out and paid because to get a new phone or get his phone repaired because the complaining witness broke his phone on the date of the alleged incident. And I'm asking the court to leave his bond as is, or in the alternative, Judge, maybe he can borrow some. He's got $250 left from the income tax return, and if you could leave it, or $5,000, he could possibly do that. No problem. He was in jail for an entire week, Your Honor, when he was arrested for this offense, these new offenses.
Pick up new cases. That's what happens. I have not asked you to do anything but be safe in my community. You're now working your fourth case. No, I don't want you to say anything. The only thing is that you continue to pick up new cases, and I can't just let you keep doing that without some kind of consequence. No, there has to be consequence to behavior, and the bill comes due. You can't continue to pick up new cases and expect good results. So I'm now going to revoke your bond. Goes with you. I can't. I have to show you that we mean business. Otherwise, we have no teeth. You know, what we say means nothing. And I'm going to tell you now that I'm entering an order for protection in all these cases. And if you violate, I can have a hearing to hold you at zero bond, and I will do it in a hurry. Protect my city at all costs. If this person comes to you, you don't open the door. If they call you, you don't open the door. Or I'm sorry, you don't answer the phone. If they email you, you don't reply. But at some point, we have to say when. Now's that time. Because of you.
Yes, Your Honor.
I'm not going to say it. That high is obtuse, and that's just, mean-spirited to go that high. But,
Reggie, it's 2 years worth of history.
not what they should tell anybody at 80,000. But I mean,
You gave the first victim 10 stitches of that.
10 stitches.
I read that, Judge.
Tell me about the second one. What happened with the second one?
The second one is this one. And then you want
Right. How bad are we talking injuries on the second?
Judge, it's swelling and then bruising back.
All right, so I'm going to do 10,002 on the first one, 5,000, 10,003 on the first assault, 5,003 on the terrorist drug, and I'll leave the second one because it is the new one. So, no, then I have no. The new one on. Do we need to file a Okay, can you, Sebastian, file a new order of protection on the old case so we can have him sign it? On
Yeah,
the
do you want it
future?
on the two victims or do something?
No, on both. No. Yeah. Mr. Johnson, you're charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to.
Yeah, Judge, as you know the details of the third one.
Say, just read it.
Officer reviewed a police report from February 4th, 2025, after the officer spoke with the complainant. The complainant stated the defendant, her ex-boyfriend, called the complainant and stated that he was going to kill her and then showed up at her job. The defendant was approached by security and fled the scene prior to contacting the complainant. On February 24th, 2025, the defiant officer called the complainant. The complainant stated that on February 7th, 2025, she told the defendant via phone call to stop harassing her, and the defendant told her he did not give a fuck. On February 12th, 2025, the complainant received an email that stated, "Skip pussy bitch, I just love you." The defendant also sent a 20-second pornography video. The video showed a female laying on her stomach, nude, and the video zoomed in on the female's vagina with with fingers being used to spread the female's buttocks to expose the inside of her vagina. The complainant recognized the hand and the fingers in the video to belong to the defendant and recognized the rodent. The complainant stated the defendant had previously emailed her on March 16, 2024 from the same email, sending a picture of himself at work. On February 18, 2025, the defendant emailed the complainant 6 times. On February 23, 2025, the defendant emailed the complainant 9 times. On February 24, 2025, the defendant emailed the complainant once. The complainant changed her phone number on February 22, 2025, because she kept getting phone calls from unknown numbers, and when she would answer, the call would hang up. The officer texted a photo of the defendant from his Texas driver's license and the complainant together by the defendant.
Pornography video that was sent.
We don't know the ID of the female in the video.
She would say whether she recognized it was her. I would imagine that there's a pulse. That's
Yeah.
it.
We haven't spoken to her directly yet, Your Honor.
Mr. Johnson, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or prescribed controlled medication. I'm going to order you not to have any contact with the complaining witness. I'm going to put a GPS monitor on you so I know where you are at all times. If I find that you go anywhere near this person, if I find that you try to have any communication with this person through any means, I don't care what it is, Snapchat, it's Facebook, social media, smoke signals, whatever it is, I will put you in jail. I'm going to do everything in my power to protect my community at all costs. I don't care who you are. Do you understand? I'm now entering into what's called a magic order for emergency protection. This is a court order that identifies Ms. Turner as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under Section 42.07 of the Texas Penal Code, which is the Stockholm statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. If you violate this court order, the state can and will probably file a violation of protective order. It's one of the worst cases that you can pick up. Do you understand?
Yes, sir.
Okay, we need to talk about bond.
Your Honor, the defendant works for Enterprise. He's an IT specialist. He's been working there for over 5 years. And, he's got ties here. He's been living in Houston for over 5 years. And he has child support for 3 children that he takes care of on the weekends. They're with family mom on the weekdays. But he does work. He has work, and so we would ask for these no threats. He's not shown anything previously, and it's not strong class. We were requesting a bond of $1,500. We have the bondsman here today.
I would be unopposed to a bond of $1,500 if he were to have a GPS monitor with an exclusion code. Yeah, so I'm unopposed to that, as long as he has the exclusion code.
Bond will be set at $1,500 then. You will get no more warnings, Mr. Johnson. Don't, I mean, you're in the free world now. At the court, if I find that you do anything, it's not going to go well. Do you understand? Okay. All right. So you have a bond company here now? Okay. He'll have to meet with y'all first for all the bond conditions, and after that, we can release him for bond. Yes, sir. Yeah, for sure. Okay. All right. Thanks, Joe. Morning, Mr. Jenkins. So we brought you out because your lawyer wants to talk about what's going on with your case. I don't know. You tell me what you'd like to.
Well, Judge, there's several things I want to address, right? His reckless driving was dismissed. The felony case that caused you to place him in county and raise his bonds has been disposed of and reduced to a misdemeanor, I guess, last week or so sometime.
So I don't know. I don't know anything about it.
So now we're stuck with 2 terroristic threat cases, one against his brother,
Yes.
spoken with his brother about that case. We were here, I believe, Tuesday, reset it to today to see if the investigator could find any audio or video that was associated with one of the cases involving crutch fitness and an employee there. It's my understanding.
So I spoke to the officer. He told me he was going that day last week, and I've reached out to him again, and now he's saying he's going today. Yeah.
I mean, the officers are busy.
Yeah.
I get, but you can't just expect them to drop on a dime to get something, right?
No.
Right, and I understand. But I think that if we were to come to a disposition in this case, like Mr. Jenkins wants, I think it's one simply just to get out of custody. And I think that
I get it, because nobody wants to stay in jail.
right, but I also think that he has arguably some good arguments to make in his defense, not only for the crutch fitness case, but given now that his brother is not on board to prosecute. I was asking at his request for a time served, stating not willing to do that. They'd like him to TRAS and whatnot. I'm partly out here asking so he can hear what's going on out here. Secondly, I see that the bonds are $10,000. His father is here present. His father came from overseas just to help address what was going on. They visited yesterday.
Where's that?
Well, I'm here to proper.
Look, Dad, come on. Thank you so much for coming.
So, both cases are set at $10,004. With that present, I'm asking for a reduction in those cases. I don't think a personal bond. I'd ask for a PR bond. I have to ask. But given that a personal bond is not on the table in both those cases, I would ask for a reduction of $2,500 per case, Judge. I say that because initially he was taken into custody. Jail therapy was part of the initial reason why, not the entire reason why. I think Mr. Jenkins has been in there since January 14th, over 2 months. I can see it on his eyes when we speak. He doesn't have the same livelihood he did whenever he was wanting to fight these cases. I think the jail therapy has worked. It's done its case, and I think $2,500 is enough to let him know that he has to be back in court, and whoever puts that money up, that he's responsible for that money in full should he not abide
It's
by it.
not just to come back to court. Every time we give Mr. Jenkins a bond, it's been a case. Since January, we're on our fourth case. And they're dangerous cases. They're not cases where it's like a rinky-dink trespass or like a theft from a Walmart. No, they're serious, dangerous cases. Your first case is a reckless driving. While you're on bond, felony. What was the felony initially? So he's on bond for reckless driving. We ordered him, hey, no more reckless driving, please. Just think about the community. Don't endanger the community. Picks up invading in a motor vehicle. Third-degree felony, looking at 2 to 10 in the penitentiary. He gets out. Then he picks up in October, terrorist threat, gets out again, and then now picks up another terrorist threat. Same note. So it's what we ask you to do. It goes in one ear, and it goes out the other ear. And the problem is now you're stuck because the bonds are high. Your dad is here, which is great because it shows support. The problem is, if I let you out, you're going to pick up a fifth case.
Sir,
Well, I know you're going to say no. You said that the first 4 times. The only way I really get to know you is how you look on paper. Because that tells me who you are. When you tell me something, for me now, it goes in one ear and it goes out the other. I know you're going to tell me what I want to hear. Little bunnies jumping in the woods, gumdrops and rainbows. But when you get out there, you turn into a different person. And it's not fair. Everybody else who complies and the potential danger to everyone. We're not asking for much. We're just asking. Don't do anything. Think before you act. I've repeatedly told you. So, I get that you feel like you look but are we really supposed to keep doing this? State, what's your position?
big case, let's go, it's not, no, I ain't fine, issues, no, I ain't there, it goes,
How isn't that just the two cases were, because they're not even in the same,
I don't,
same transaction. I don't understand how these things are happening now, because I see a lot of judges complaining that, you know,
I did not file that, I was like, so I went to check and,
so who was the first terrorist?
The first term picture was Probable.
Who's the second?
Second one is a manager at a gym.
Here's what I would like to do. I would like to have him TRAS to see how we go forward, because I just don't know. TRAS is an evaluation where we have clinicians talk to him and see. They ask him all kinds of questions about his life, about his history, any drug history, you know, living situation. They ask, and they determine, you know, okay, this person may need treatment, this person may not need as intensive treatment where he can be on the outside and doing it. I don't know how to go forward, but it scares me because I don't want him to become a case. I don't know what he's doing in life. You know, did you graduate from high school? How do I know that? You know, I mean, just you're headed nowhere. Where? And we don't want to see that. We don't want you to end up as a mistake. I mean,
Sure. I've been trying very, very hard to get a startup in sales because I want to do sales. That's the best way for me to go without having a degree because I didn't want to go to college. I wanted to be an entrepreneur, and so doing independent contractor work, it allows me to be able to make money, you know, on my own time and then invest into what I want to invest into on the side. Because I don't believe that working a job for the rest of my life is a way for me to live my life. And I agree with you that I keep on picking cases, but it's not because I want to start trouble. It's just because I have too much time on my hands, and the things that I want to get started haven't gotten started yet because I procrastinate a lot. I know that I do that, but it's not because I can't control myself. I have a lot of self-control, and I can if you let me be free, it's
Terrorist
not.
threat says the otherwise. Terrorist threat says that when you get angry, you pop off, you have no self-control, you start throwing out threats, right? Without just no self-control.
Well, I would say, Judge, on that one, just this is at a gym, but there was also a basketball game that had just happened. So it's important, and the reason why I brought up the evidence because you know there's two sides of the story. So I just needed to.
I always.
Right. We understand that. I want you to know that you know we're advocating for him as well. We are doing the investigation, and I worry that if he just signs to get out, that it puts him in a cyclical sort of situation. One, and two, that he's only doing it just because he doesn't want to get out. And that's why I'm addressing the bonds. And that's why I was addressing the bonds because and this is not even a guarantee that father is going to pay the bonds. This is just a.
Let me ask you this: if we let you out, where are you going to go? Where do you have to?
My mom, she'll let me stay back at the house. I know that if she doesn't let me stay at the house, then I'll find a place to stay. But
They'll let you out to the street. They'll eat you alive.
well,
The only way that I would think
I have family on the outside.
they're not going to take you.
That's not fair. I'm in jail because I had a place to stay and now I don't because I was in jail. Being in jail is not the place for me. The only way to elevate my life is.
For Mr. Jenkins.
I wasn't in jail before those cases. I've been in jail now, so I understand my consequences more. That's what jail is for, to learn your lesson.
You live across the country, or
We haven't lived in New York for the last 6 months. Because I'm in New York.
who else? Is there anyone here that's going to take Mr. Jenkins in?
Only the crossing bridge, everyone.
He's burned it. God, hell, dude. You know, it's never good to burn a bridge because you never know when you need to cross it. When you act like an a-hole to everybody and you shut everybody out, this is the exact example of why you don't do that. I would consider if you had a place to go, because I'm telling you now, I'm not letting you out to the street. If you have nowhere to go, then that's sent
Find
to
a place to go, but I can't find a place to go if I'm in jail. I have nobody to call in jail. Nobody answers my phone when I'm in jail. So if I stay in jail, that's gonna be my life forever. I'm gonna be a kid that had a chance in life to a kid that has a life in jail now because of a few mistakes that I know not to make anymore.
Let's see a lesson.
I'm able to go through the rock judge and find some kind of social program, and work that way and provide evidence to the court. They can house him. My parents will help me find a homeless shelter. They'll help me find a homeless shelter to stay at. Like they did that before. I just don't want to move in.
Really?
We're going every direction. She has six boys, and he's number 5. Auntie, his grandmother, and he shoots everybody. So,
I've stayed in a homeless shelter before, and I've done well in the homeless shelter. I was able to take care of myself and function in the homeless shelter, and they helped me. They helped me find the homeless shelter, so I can find a place to live. But if I'm in jail, my life gets worse. And
I know you're desperate to get out, but I don't understand what could have been so bad that you burned so many bridges with family and everybody in your family. What the hell happened?
I started.
You know, just reflect on that. I mean,
the evaluation would be great. See what evaluating for. Smoking the injuries take evaluation. So,
that's big. You know, the problem is, Mr. Jenkins, is that we get a lot of people here that they're supposed to take medication, right? And they start to take it. Things go great. The problem is that things do go great when you take your medication. And a lot of people say, you know what? I don't need this anymore. I'm doing great. And when they stop taking it, everything turns right back into shite. You know? That's the problem. When you're taking your medication, things go great. You must continue to take it.
I something. The medication.
Not talking about the cases.
I know I'm talking about the medications. The medications, they were making me drowsy. So I was in process of getting on new medications that were uppers and not downers because at the time I didn't have a car, so I was going through a lot more shit. So the same position I'm gonna be in now, so I know that's not a good argument. But finding a medication that has me up instead of down, so that I can function and find a job and make money, because really it's not my life is bad and I'm going through what I'm going through because I'm not where I want to be in life. I don't have any money and I can't take care of myself because of that. So that causes a lot of mental illness. That's what you can call it, mental illness, but it's really just going through life and having stress going through life. That's the problem I'm dealing with, not having any money. So once I have money, you'll see a completely change. It'll be like I'm on the best medication ever once I have money.
Do you think that me just letting you up, you're gonna get money?
I'm not saying that, but I can show you by going to the therapies and the classes that I'm doing better and that I'm trying to elevate my life to a point where I can take care of myself and I don't have to depend on anybody in my family. And then you'll see that proof change once I'm in a position where I can take care of myself. I can promise you that you'll see that proof change as soon as I can take care of myself because I have money now.
Right. I'd like to do a TRAS to see how we go. I don't know. But I'm going to tell you now, I'm not letting you just out to the street. So, do you mind?
I will research through the progress.
No. But also, perhaps you can try to make a good faith effort to reach out to the family, see if anyone. I'm happy to talk to them to try to help convince, to see if they'll
speak extensively, but yes, sir.
So we're talking about the Job Corps, so the Job Corps in St. Marcus that he qualifies for it, $90. So he can go to Job Corps, learn the trade, stay up there, he's willing to do that.
Problem is that he's going to do it.
Right.
Yes, sir. I will do it. I'm very
You're in jail. Everybody say anything just to get out of jail. And when you get out there, though, what's really going to happen?
I don't have a car, so I need to find a way to apartment. So any job right now is a good opportunity for me because I have to save up to get a car to take care of myself.
Mr. Jenkins, where is job? Is it just in San Marcos? There's nothing here?
That's what I want. Not the closest.
Because what I'm thinking is that we probably do something to try to resolve these cases and perhaps make that a condition that he does job.
Is it possible that the court could, order that? As a, well, I'll discuss it whenever we.
Right. I would say that we do it as part of perhaps some kind of global agreement where, first have him TRAS, let's see what they say, and then perhaps we make it a condition that he does job. And the thing, I don't know, it's in San Marcos. I have an issue. I don't know how we can survive, right? But if there's something here, that would be great. There's something close for. You try that? First have them TRAS.
Sure.
See what they say. Come back on Monday or probably Tuesday or Wednesday. Because we got to give him a couple days. He'll be clean now. He's been in custody. Well, I hope they don't have to open the jail anyway. I know that he's been in custody for quite a while. But if we do let him out on, say, some kind of diversionary program or probation or whatnot, he will absolutely be tested in a lot. Because I would make it a condition that he gets tested a lot. And I'm going to tell you now, if you do get out, one of the conditions will be that you take your medication. One of the other conditions is that you get your driver's license. One of the other conditions that, we'll try to find you some kind of housing so that you have somewhere to stay, because I don't want you out on the street. And that you get the job. So, we want you to see, I don't want you to just stay in jail. I don't want you to be sick. I want you to leave here better than you can. But me, just letting you out now, just for shits and giggles, that would throw you out to the wolves. Because I think that you, with the proper structure, you're going to go do what you've been doing for the last.
I need to be transferred because in my pod they were touching on me inappropriately and saying sexual things that were making me uncomfortable. And just not regarding that, that's another issue. The reason I was hesitant to sign and defer is because I was expecting to see, I got to make sure that the evidence is correct as well, And I really wanted to see.
You don't have everything?
No, I'm saying the surveillance that we're waiting on from the investigator. I was.
Oh, this is from what you were talking about. Okay, I get it.
This is not right. No. And I'm saying, look, and I think I didn't want to, Judge, just have him sign something just so he can get out. I understand he's in jail, and I understand it's bad in there.
TRAS. Sure. In the meantime, try to get the video, subpoena the officer to get here, because it's been since October.
She's been looking for him. I'm not saying they haven't done anything. I'm saying it's my job as well. I got to make sure that,
Sure.
he's held and.
If you subpoena the officer to come to court, that fully, you know what I mean?
Yeah, that's why I'm keeping me all right.
I didn't feel that as well.
Not like
So, we'll have it evaluated Monday. Let's give it 3 days to get the results. In the interim, Matt's going to get all the evidence so they can see the surveillance, they can see everything, so that all you guys can have a meeting and see what is out there. And then perhaps maybe like Wednesday or Thursday, we can come up with a plan on how to go forward. Is that okay? Matt?
Yes, sir.
How long are you going to be here?
I'm going to be here until we're done. I was supposed to leave on the 29th.
Okay. We'll try to do it as fast as possible. Yeah, well, sure, absolutely. My main concern is where is he going to live when he gets out? Because car's gone. Car's gone.
So I have 3 vehicles out in Michigan. I don't know if you have a license or anything.
Can you run his license?
Yes, sir.
Before you just start driving and getting out there, make sure that you yourself are good. Before you start doing that.
I'm very confident with this thing.
I know you are, but I mean, taking the medication, if you're taking any, so that you get everything, you do it in steps. You don't start running or start walking. There's a process.
I need to be out of jail. My mental is way worse when I'm in jail than when I'm in the free world. In the free world, I'm on way better position to take care of myself and elevate my life to where I need to be. In jail, it's the opposite.
This is what you consider when you're out there in the free world.
And I understand. I wasn't considering that before, but I will now. That I've been in jail, I understand what jail is, and there's a place I don't want to be. I understand what I'm dealing with on the free world and what I need to do in the free world in order to not come back to jail. I understand.
Mr. Jenkins, we're in the home stretch. We are in the home stretch. Matt, in the interim, if you could please just find a home. I'm happy to talk to any family members to help try to convince.
The shelter he was in before. The shelter he was in before was an age group. He had that beds. So he wasn't in a homeless shelter. He was in a place with children though, from 18 to like 21. But I think over. So he won't ever get him in one of those. One of the places he go to a real shelter, he has to be in his spot. He live on the street or go to job for. So he doesn't understand that those shelters doesn't exist anymore. Kid shelters.
Yeah, I understand that, sir.
He's aging out, so he hasn't taken his medicine. He's 22 now, so we can't make him take his medicine. He'll let him sleep.
I can, as a condition of anything to release. So we will make it. And if it doesn't start happening, and if he doesn't take the medication, he'll stay with me. And we'll keep doing this until it takes. It's been hold on to you for 3 years, man. Really. All right. I think we're good. We got a plan. For, I guess, Tuesday or Wednesday. And we'll come back and then hopefully we can have everything resolved. Okay? Thank you so much for coming. Really appreciate it. You are Adan Ruiz.
So,
Mr. Ruiz, you're charged with 2 cases. You're charged with burglary of a motor vehicle and tampering with a government document. On the burglary case, you're facing up to a year in jail. Likewise with the tampering. Up to a year in jail and or a $4,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. Do not afford one. One will be appointed to you.
On March 20th, 2025, an officer was dispatched to a burglary of a motor vehicle that occurred in the Old Navy parking lot in Harris County, Texas. The officer spoke with 2 witnesses who viewed the incident. Witness 1 stated the suspect's motor vehicle pulled up to the complainant's motor vehicle, and the suspect was wearing a camo hoodie and had gotten out and pulled the door handle of the complainant's motor vehicle, attempting to open it, setting off the alarm at the same time. Witness 1 advised the suspect got back into the car and drove to another area of the parking lot, parked, and waited for the alarm to stop alerting. Witness 1 stated once the alarm stopped making noise, the suspect drove back over to the complainant's motor vehicle, parked, and the suspect in the passenger seat got out and was able to make entry into the complainant's motor vehicle. The complainant advised she was walking up to her vehicle when she saw a Hispanic male wearing a camo jacket hoodie sitting in the driver's seat of her vehicle. The complainant stated the suspect saw her walking up, jumped out of her vehicle, got into the passenger side, got into the passenger side of the vehicle waiting with an unreadable paper plate. And the complainant advised she heard a male tell the driver to go, go, go. Another officer advised he was patrolling when Gold Tahoe, which was the description of the vehicle before, driving at a high rate of speed passed. The traffic stop was initiated of that vehicle. The officer was able to send pictures from the witness showing the suspect vehicle leaving the location to other officers who were able to verify the suspect vehicle. After further investigation, search of the vehicle, the camo jacket was found in the seat, and a flat-pointed screwdriver consistent with the tool that would be used to break the lock on the complainant's vehicle door. Defendant 1, Ruiz, is a registered owner of the Tahoe, but the motor vehicle was displaying a counterfeit paper tag and did not come back registered to any person or any vehicle. Defendant 1 was identified by his VIN number and booking photos. Defendant 2, Serta, was identified by his VIN and booking photos.
Who was the one who actually went allegedly into the car? Was that Serna or was that Ruiz? Is Serna here?
No, Jeremy.
Oh yeah, he has 2 felony warrants. On Cerna, bond gets revoked at 10,002.
You're not able to tell which the suspect was the one allegedly maybe came up with you, the one that physically entered the vehicle or within somebody.
Mr. Ruiz, since 2020, felony evading, theft, felony retaliation, assault of a family member, felony unlawful carrying of a weapon, felony theft, and now tampering and a burglary of a motor vehicle. I want you to understand that I'm going to do everything in my power to protect my community at all costs. I don't care who you are. I don't care what color you are. If you're a small farm animal, I will do everything in my power to protect my community at all costs. You are not to hang around with defendants. I'm going to put a GPS monitor on you, and I'm giving you a caution. I don't want you out in the middle of the night. You're not to use alcohol, illegal drugs, and I'm telling you now, I'm going to test you like crazy. If I find that you're using, it's not going to go well for you. You understand?
Sir.
What do you do in life, Colin? You work?
Sir.
Did you graduate from high school?
Sir.
You did?
No, sir. I got my diploma. JD.
What are you doing now? Do you actually, are you working?
Sir.
I want you to know that you're actually working and that you're going to be a productive citizen. When people have too much time on their hands, it becomes self-destructive. And you now are headed for a 25-year sentence or an actual death sentence. People in Houston, they like their guns and they like their cars. And if you muck with the wrong person, they're going to shoot your ass dead. It happens at least once every other month here. We have someone who's dead because of a gunshot because they breaking the wrong. You understand?
Sir.
You are not to go within 500 feet where this person lives, works. Is it an apartment complex? What is it?
We'll just have an old Navy parking lot, Your Honor.
I don't want you going anywhere near there. Is it like a mall? Guys, 9 p.m. to 6 a.m. No drugs, no alcohol, no weapons, no contact with the co-defendant. GPS monitor today with a 500-foot exclusion from where this offense occurred. I will give you a lawyer today. To do everything in my power to help straighten up and fly right. And if you force my hand, I only have one place for you. You understand?
Sir.
You hang with dogs. You get things.
It's a strip mall.
Whatever that strip mall is not to go there. And then, so, Blaze, if you don't mind sending that to them, please. All right, Mr. Reese, I'm going to have you sign a receipt with Victoria. I'll have you meet with pretrial, and then I'm going to have to take you to the jury box so we get you a lawyer.
Sir. Tomorrow.
Okay.
Today on Joe Greathouse, he's got a pending DVR for a high blast.
Great House, come up. This is the one that you said that he's a truck driver. I had initially taken away his privilege to drive, and then we gave it back, right? Now, testing positive for alcohol.
It's a high blast. And you found
Sure.
your business. I had my client, the other part about the brand, I did a flash diagnostics and take an alcohol test. It shows negative. Now it is a couple days later.
I mean, really?
But if somebody's drinking,
Really?
enough, they're gonna violate on the machine. Why would they stop? Yeah, such an alcohol problem. You ever know the machine?
That's, no, I don't believe that person. That doesn't fly. The only thing I know is that
Judge.
he didn't do a retest like he's supposed to right afterwards.
So what he told me is that he was getting in the car to start a shift. He has to start real early, right? You used mouthwash, right? That's what you're telling me.
Really? Well, and now it's mouthwash?
Well,
What's next? Abducted by aliens?
I don't think I'm being consistent. He tells me you alcohol. He told me
3 days later.
I admittedly, I told you, admittedly, it was 3 days later. Well, what I did in the report is, somebody's got, a bad enough alcohol problem that they can't stay straight on a machine. Why would they stop doing something? People that are chemically dependent on well, my client, what I told my client, Judge, is you can't use any alcohol products at all, right? You understand, correct? So you've got some mouthwash now that is the hydrogen peroxide, correct?
Great house. I'm now again taking away your privilege to drive. And I'm now going to put a scram on your ankle so I know that you're not consuming alcohol at any time. And if I find that you do, I'm well within my right to put you in jail right now, Mr. Greathouse. So be lucky that you're not going to jail right now. But if I find that you test positive, and I don't care if the Queen of England comes down and says, let's have tea at breakfast, you test positive for alcohol again. Do you understand me?
Your Honor,
What are you gonna say?
the defendant's license is, coming back as ineligible already.
Sorry?
Your license is ineligible as it is.
I'm gonna have to look at that. I'm not a receiver.
They have access to the Texas Department of Public Safety's driver's license to see whether a license is valid or invalid. They've looked it up, and they're saying that your license is not valid at this time. You're not allowed to drive regardless. It's suspended at this time. I mean, I know that you're looking at me like this, but the system is saying so. Don't drive. So what I'm going to do is I'll have you come up to your sources that you're not going to drive. After that, you'll get with pretrial for your bond conditions. They're now going to put a monitor on you. This detects alcohol through the perspiration of your skin 24 hours a day. Don't use. You need to be cognizant of everything that you put in your body. You know how many, if I had one strand of hair, every time someone told me that they use mouthwash, my hair would look like Mr. Johnson. Really. That's why we advise every single person, as soon as they're given bond conditions, do not use this, do not use that, do not use this. Regardless as it is, your license is now suspended, so you can't drive regardless. So you guys need to figure whatever that is out, and then we'll talk. All right. Thanks. You're Ronald Umanzor. You speak English?
Yes.
So you're charged with driving while intoxicated. The second offense. You're facing up to a year in jail and a $4,000 fine. We are going to be probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to use. Okay.
On March 20th, 2025, an officer observed the defendant's vehicle in the street and observed the defendant talking to prostitutes on the street in or around the 3700 block of Probable. The officer followed the defendant's vehicle into a nearby motel, and they were almost struck head-on by the defendant. The traffic stop was initiated. The officer observed the defendant to be the driver and sole occupant of the vehicle and observed the strong odor of alcohol upon his breath. The defendant refused to answer questions without avoiding questions. The officer observed the strong odor of alcohol upon his breath, slurred speech, and bright glassy eyes. The 15s were conducted 6 out of 6 on the HDL. The defendant refused to walk and turn in one leg stand. The defendant refused to provide bright glassy.
Just on how I read the offense report, I read it after he almost struck them, and then followed him, and then he came to a complete stop in the roadway, and then they stopped him. So I don't see any traffic violation, any here.
I'm looking at the side.
Yeah, that's for me, it's a distinction for what was wrong to what.
It says, they viewed the defendant speaking to prostitutes on the street and around the 700th block of Tidwell Road. Officer stated, people, sorry, Judge. Yeah, thank you. Officers stated that they followed the defendant's vehicle into a nearby motel and they were almost struck head on by the defendant's vehicle as it exited the motel parking area. The officers then stated that they have activated their emergency lights in the patrol vehicle and got behind the fence.
They let him drive a little bit and then pull him over, or was it?
Yeah, he got into my understanding, he got into the roadway, and then he came to a stop, and then they stopped him. So I don't see any traffic violation. I don't see any crime being committed.
I mean, I don't know. I mean, perhaps there were. She's saying that he almost hit them, right? And maybe he went out a little bit more and sees them, and I don't know.
Oh, no, yeah, they're asking you to
Thing that
assume.
hits them, so at that point they pull him over. Go get the video. Go get body cam. You see something different.
Sure.
I do think that there's sufficient probable cause to go forward in case Mr. Manzor. Can you run the license, please?
Yes. His driver's license is eligible.
I am now placing a restriction on your license, Mr. Manzor. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. I'm also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond in jail. No more PR bond. Do you understand?
Yes, sir. No, sir, Mr.
Yes,
Officer.
sir.
Likewise, you are not to drive any vehicle unless it has an ignition interlock. I'm sending notice to DPS and officers so that every single officer in this state knows if you're driving a vehicle that doesn't have a blow and go in it, they're going to arrest you and put you in jail. Do you understand?
Yes, sir.
I'm not asking much. All I want my streets to be safe, and I'm going to do everything in my power to protect it. You got a great lawyer here. Listen to Herman. He'll take care of you. Because you have a lawyer, I will waive your appearance, but you must stay in touch. He tells me he can't get a hold of you because you're playing games and you've gone AWOL. I will issue a warrant for your arrest. For now, I'll have you go to Victoria Center Reset. We'll have you get a shot for your bond conditions, and after that, you're free to
I
go.
think you already have it, you know.
All right.
Sir, what's wrong?
So I'm here on Mr. Hunter. He had an issue, he bond forfeited, he's back for an arraignment today. I've spoken with the state, they've made an offer. We're asking for one setting for, Mr. Hunter to consider that offer. And then the state is gonna eval the case if not, and if, reasonable minds still disagree.
Where is this? I don't even see Mr. Hunter.
Mr. Hunter?
Has he made
Yes, he bonded out.
sending him for a drug test right now?
Oh, sorry.
Right.
I know.
I don't know what you have offered. I like it. I'm going to tell you now that it's not going to be the revolving door anymore. No more revolving doors for you, Mr. Hunt. You understand? If I find that you're using, it will not go well for you. You come to court whenever you want to come to court, and that's not the way it works. I'm sending you now for a drug test. I guess we'll come back Monday and address the results. It's now 11 o'clock. We just don't know if it's enough time.
I mean, Mr. Hunter just informed me he drug tested yesterday. So I don't know if we have those results yet.
The pretrial people,
But yeah,
the pretrial people got a lot of the drugs this month. One
I don't know how, because there was no order from us. If he's on the land, and then he makes bond, those bond conditions are valid. You know,
I got
so
okay. Okay, so when he was released, there were bond conditions in place and he needs to report on Monday and Thursday for drugs.
Okay.
And so he did that yesterday.
You test?
Yes.
You will now test every Monday and Thursday. You test positive for anything else, it's not going to go well for you. You understand, Mr. Hunt? Now is the time for you, once again, to address any issues you may have. If you don't, I'm going to address it for you. So we'll let him go now.
Okay.
Continue with the same bond conditions that we've always had. And then he'll test again on Monday.
And so we're, just to let you know where this case is heading, the state has asked for one setting to eval it, and then, if reasonable minds still disagree, then we're gonna, set it for a dispositive motion. With the work commission.
I don't know if I'm just going to set trial.
Okay, we can do that too.
There's way too much drama there. I'm not going to,
Well, we'll have to see.
let a jury decide.
So you'll go do,
So,
we'll stand down, Judge.
yeah. Okay. Anna will continue like always. He'll be back Monday.
Go.
Thank you.
I will, who is in custody?
I'm bringing you out now because I have great concern with your cases and the way that your bonds are set at this time. It appears that in September of last year, you pick up a felony assault of a public servant and an evading arrest. A couple months later, an aggravated sexual assault, and I'm assuming he's out on bond for all this stuff, and now he's picked up another case. You now stand charged with unlawful carrying of a weapon. You are facing up to a year in jail and a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you soon.
On March 17th, 2025, at approximately 2:46 p.m., officers were dispatched to 3099 NASA Parkway, Houston, Harris County, Texas, for an intoxicated male who had fallen off his bicycle and dropped his firearm onto the ground. Upon arrival, the officer observed other officers detaining the defendant and transferred custody to the affiant. The officer spoke to the witnesses, who stated they observed the defendant in an intoxicated state, walking along the sidewalk, stumble onto the ground, and they observed the semi-automatic firearm fall out of the front pocket of his hoodie. Witness 1 retrieved the firearm from the defendant and handed it to witness 2. Witnesses then had held the defendant until police arrived. The officer attempted to question the defendant, but the defendant was unable to provide the officer information as to why he was in possession of the firearm due to his intoxicated state. The defendant was identified via his U.S. residence.
You see that? You have an ice cold, you know? Mr. Cruz, I'm going to find that there's sufficient probable cause to go forward with your case. Did you have anything on it? I think Mr. Cruz gave chance after chance for you to remain out on bond. I find by clear and convincing evidence that you refuse to comply with bond conditions. There are no non-financial conditions that we can do that will enable you to comply. As a result, I'm now going to revoke your bonds and I'm going to set them all at $10,004. Because of the actions now, I think that you now have an immigration detainer. So, do you know anything that's going to happen with that by chance? You know? So I don't know if you're going to get out. If you get out, I'm ordering you to be under home confinement. You are not allowed to be released unless you have a GPS monitor on your ankle. And then I'm also on your other ankle. I will put a gram monitor so I know that you're not consuming anything. You're not to consume alcohol, illegal drugs, unprescribed controlled medication. You're not to be in possession of any weapons. Do you understand, sir?
Yes.
Okay. You need him to sign the conditions and we'll have to
Okay.
we'll set him. It looks like the felony is set for, you may. Let's do 30 just in case, and then if nothing's happened in the felony, we can do another 30 at that time. So, okay. Thanks. So,
Bam Judge drops the hammer with no probable cause. That's huge. It's a reminder that even when someone matches a call slip, the law requires specifics. What crime, against whom, and why. Without that, you can't just toss someone in jail. The courtroom just flipped the script in seconds.
morning, Mr.
Hello, sir.
So you're charged with reckless driving. You're facing 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On March 21st, 2025, at approximately 10 p.m., an officer was investigating a fatal motorcycle accident with emergency lights activated, and the road was shut down from both directions. Accident investigators notified dispatch of a vehicle which disregarded all marked units and drove through the accident scene, almost striking officers and reckless drivers at the campsite. The officer observed the vehicle traveling at a higher speed, and cut through an Exxon service station parking lot and turned out another road. The officer followed the vehicle and initiated a traffic stop. The vehicle accelerated and began darting in and out of lanes without using a turn signal. The vehicle then turned and came to a stop. The high-risk stop was conducted and the defendant was taken into custody. The security sweep of the vehicle was conducted and the officer observed 2 baggies of a green substance in plain view on the driver's side seat known from trading experience to be marijuana. The defendant was identified by his driver's license, and the defendant was transported back to the accident scene, where the accident investigators confirmed the defendant's vehicle was the same vehicle that disregarded the marked patrol vehicles and disregarded the safety of the people on the scene. Other officers who witnessed the defendant's vehicle confirmed this. Deputy Chicoya advised that the defendant's vehicle overstruck multiple patrol vehicles and had approached officers while they had to abruptly move out of the way. And then Deputy Chicoya observed the defendant's vehicle almost struck 2 rougher drivers who were authorized to be on the scene. The rougher drivers confirmed this. Witness crossed advised the owner of the vehicle to stop. The defendant's vehicle began to accelerate faster. The defendant acknowledged he drove through a road.
Mr. Davis, I'm going to find if there's sufficient probable cause to go forward with the case. You run his license. Please leave him down to us.
His driver's license is not on the ground.
Mr. Davis, you are not allowed to drive. You will be signing an affidavit with me today promising you're not going to drive. I don't care. Jesus comes from heaven and needs the right to church. I'll find that you drive. You can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. You understand? I'm going to do everything in my power to protect my community. If I find that you drive, much less drive maniacally like this, as they allege, it's not going to go well for you. If you want to drive, go get a license, get liability insurance, and then we can talk. But until that point, if you do, it's not going to go well for you. You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with her. If she tells me that you're playing games, you're not responding to phone calls, text messages, you've gone AWOL, you put in the case, I will revoke the bond and put you in jail. Do you understand? I'm not asking much. All I want my streets to be. I'll have you come up here, swear to us you're not going to drive. I'll get you a Victoria sign and release it, and then you're on your way. Thanks. All right, please. All right, good morning, Mr. Gosby. Ma'am, you're charged of driving while intoxicated. You're facing up to 6 months in jail and a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be reported to you.
On March 20th, 2025, at approximately 9:24 p.m., Officers observed a black Chrysler traveling southbound on Kingswood Drive, noting that the rear license plate was not illuminated, making it difficult to see after a stop was initiated. Upon activation of the emergency equipment, the motor vehicle accelerated rapidly. Based on a loud sound from the motor vehicle's exhaust and speed which it was traveling, the officer believed that the driver was attempting to elude. The motor vehicle made a sudden right turn into a private drive and continued before coming to a stop. The officer made contact with the defendant, who was the driver, and also made contact with the front passenger, who was identified. The officer observed a strong odor of marijuana. The defendant was detained due to further movements inside the vehicle. The officer observed multiple open container beverage vehicles, including a Four Loko and Fuzzball cans, in plain view in the rear passenger area. The officer observed a black bag in the front passenger seat with a 9mm handgun and a green substance inside. The substance was identified as marijuana due to the officer's training and experience. The defendant admitted to possessing both the handgun and the marijuana. The officer observed slurred speech and a strong odor of an alcoholic beverage on her breath. The defendant stated that she consumed one alcoholic beverage at approximately 9 p.m. The defendant performed at the best keys. The HDN was a 6 out of 6, the walk and turn was a 7 out of 8, and the one leg stand was a 1 out of 4. The DSC was read and the defendant consented to read, which the results were a .121 and a .116.
Prior to DWI, and then does she have a license?
DWI is for license ineligible. It is eligible.
Right, but no prior to DWI? Okay. Mr. Cosby, I'm going to find that there's sufficient probable cause to forward the case. I'm ordering you as a condition of your bond to consume alcohol or illegal drugs. I'm going to randomly pick. If I find that you're using, it's not going to go well. I'm telling you now, I will test you 45 to 50 days from today. If you're still using, it's not going to go well for you. Do you understand?
Okay.
You are not allowed to drive unless you have a valid Texas driver license and car insurance in your name. That is also a condition of your bond as well. Do you have the ability to hire a lawyer? You want to apply for an appointed lawyer?
Yes, please.
Deputy Miranda's going to give you an application. I'll have you fill it out. And have you sign a receipt of Victoria, and then we'll have you take a jury box. Please. You are Rafael Garcia. Garcia, you're charged with driving while intoxicated. You're facing up to 6 months in jail and a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 23rd, 2025, the officer observed a vehicle traveling at a very high rate of speed. The officer was unable to control exact speed, thus the officer's low experience, and the back of the vehicle rapidly after vehicles determined that the vehicle was well above the 35 miles per hour posted speed limit, and a traffic stop was initiated. The officer made contact with the driver and observed an odor of alcoholic beverage on his breath and person and watery eyes. The defendant admitted to drinking a mixed drink at a pharmacy earlier in the evening, and activities were conducted. It was a 6 out of 6 on the HDN, a 0 out of 8 on the walk and turn, and a 0 out of 4 on the one leg stand. The DSC was read with by specimens and blood marks.
Okay. Any prior DWI, and does he have a license?
No prior DWI, his license is not.
Eligible.
No.
Garcia, you're not allowed to drive. You do not have a Texas driver license. That is a condition of your bond. If I find that you drive, it's not going to go well for you. Do you understand?
Sir.
You're also not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, likewise, you will go to jail. No more PR rounds. Do you understand?
Sir.
This is an affidavit that you're going to sign with me today, promising you're not going to drive. Heed this warning. If I find that you drive and you can't justify it by any means whatsoever, if I find that you do, it's really not going to go well for you. I can have a contempt hearing and you're facing 6 months in jail every time you drive. Do you understand? If you want to drive, go get a license, get car insurance, and I will do backflips letting you drive. But until that point, I find that you do. Get ready. Do you have the ability to hire a lawyer?
Sir.
We're gonna give you time. I'll have you come up here, swear test, you're not gonna drive, and you can make first center reset, you'll go with pre-trial, and then you're out of here. Mr. Herrera, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. This case is 143 days. Do you mind reading what happened, please? So, you were given the general order bond. Looks like you took off. It looks like we did probable cause, I'm assuming. I found probable cause at the time. We ordered you not to drive, and then I guess went AWOL. You've now made a surety bond. So, yeah, do you mind reminding me what happened, please?
On November 5th, 2025, a traffic stop was conducted on the defendant's motor vehicle after it was observed that he had expired registration. Upon contact with the defendant, the officer observed watery, bloodshot eyes and the odor of an alcoholic beverage. The defendant
He's driving. Oh, I mean, this is this case. Because you just picked up a felony, see?
Yes, so PC.
So I guess, yeah, go forward with this, and then I want to know what happened in the felony.
Absolutely. The defendant admitted to drinking a can of DC Budweiser that was found on the passenger floorboard. The CFT was conducted. There was a 2 out of 6 on the SGN, 6 out of 8 on the walk and turn, and a 1 out of 4 on the one-night stand. The DIC was read and correct, provided unacceptable samples. The defendant made consistent to blood, and a blood draw was detected. And we do have the results of that blood.
You do or do not?
We do. And it came back for 0.05 of ethanol as well as methamphetamine and THC.
Okay, what happened in the felony?
On March 22nd, 2025, the officer observed a vehicle displaying a suspicious fire tag, and a traffic stop was initiated. The defendant, the driver, provided a Texas driver's license, warrant checks, provided a Texas driver's license, and the warrant check revealed an outstanding warrant, which led to his arrest, not the DWI. During the inventory search of the property at Pasadena jail, officers found a clear zip bag containing white crystal-like substance identified as methamphetamine, which weighed 1.7 grams.
I'm sending you now for a drug test. I want to know what, if anything, is in your system as of right now. If you fail to go test, if you fail to come back, I'm going to revoke your bond and make it so high you will have hair falling out. Do you understand, Mr. Hart? And the next time you miss court, likewise, your bond will reach the clouds. Do you understand? So take your seat, Paul. Good morning, Mr. Juarez. Sir, you're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be reported to you.
On March 22nd, 2025, officer for this past from 2 a.m. to 3:30 in Probable at 2717 Stonybook Drive, apartment number 411 in Paris, Texas. The officer observed the defendant step through a broken apartment window from the outside of the apartment. The complainant stated that the defendant began banging on her door and a window, trying to get inside. The complainant stated that she had no idea who the defendant is and she had never seen her before. The defendant then broke the apartment window with his right fist and appeared to be trying to get inside the apartment. The complainant stated that she was scared for her and her children, who were also inside the apartment.
It's a mischief.
The complainant stated that the damage was $100. The officer observed the window to be broken. He was being attacked on his right hand, breaking the window, and there was also blood.
You were very lucky. You're not charged with a series of felonies. Mr. Juarez, I'm going to find that there's sufficient probable cause to go forward with your case, and I'm now going to put an ankle monitor on you so I know where you are at all times, and I'm giving you a curfew. If I find that you're a danger to my community, I will have one place for you. Do you understand? You are not to consume alcohol or illegal drugs. I'm sending you now for a drug test. I want to know what, if anything, is in your system. If you fail to go test, if you fail to come back, we'll revoke your bond. Do you understand? You're not to be in possession of any weapons. You're not to go anywhere near where these people live, work at all. Any connection, you think?
The defendant did state on the scene that he believes that he was at a different apartment and suddenly being able to let him inside. So he's saying more.
Regardless, I'm going to send it for a test now. I want to see what, if anything, was on the system. Guys, on everything, waive the fees for everything, please. I'm going to send you for a test now. Come back. Do you understand? If you don't test, if you don't come back, it's not going to go well for you. Test. You literally pled guilty, not 10 days ago. Now you're back again. You now stand charged with the offense of fleeing a police officer. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. Do not afford one. One will be appointed to use.
On March 20th, 2025, officers were conducting an active patrol on the 15,300 block of Corona Del Mar Drive in Harris County, Texas, and observed a black GMC Sierra traveling at a high rate of speed in a residential neighborhood. The motor vehicle attempted to slow down once they noticed a marked patrol vehicle by hitting the brakes. That called the officer from their tail light. The officer quickly turned on emergency lights and sirens to attempt a traffic stop. The motor vehicle failed to signal, taking a right-hand turn, and continued driving while the officer was behind the vehicle with lights and sirens. The defendant continued driving approximately half a mile at speeds ranging from 50 to 20 miles per hour in a residential neighborhood. The defendant disregarded 2 stop signs and then
How fast in the residential neighborhood did you say?
Sorry?
How fast?
10 to 20 miles per hour. The defendant disregarded 2 stop signs and then parked his motor vehicle in front of his residence and opened the motor vehicle door for the defendant was sitting. He stated that he was coming home when asked why he didn't stop. He was identified by his license.
So no license?
There's no license.
Mr. Melendez, you're not allowed to drive. If you do not have a Texas driver's license, you don't have liability insurance. You're not allowed to drive. You will be signing an affidavit with me today promising you're not going to drive. I don't care what you need to do in life. If you don't have either, both, and permission from us, do not drive. Do you understand? So 10 days, put your arms down. Since the last 10 days that you were here, what have you done to change your life? What better have you done?
So, I'm always on school. Right now, I'm doing my job. Chick-fil-A.
That is now a condition. You must do one of either, in school or a job. I'm going to appoint your lawyer today, and I'm going to bring you back into it to see what you have done. If you've done nothing, it's not going to go well. You understand? All right. I'll have you sign a reset. I'm going to have you take this to the jury box. So you're on bond for an interference and a failure to ID from November. A month later, you pick up a criminal trespass. And now you pick up a 4th case, another criminal trespass. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 7th, 2025, an officer was made aware by his manager of apartment complex, courtesy officers that the defendant was trespassing on the property. The officer stated that he observed the defendant walking in the hallway of the property, and due to previous encounters, knew the defendant to have a criminal trespass warning from the property. The defendant was detained. The defendant has had numerous criminal trespass warnings from the location and a recent arrest for criminal trespass due to being on the location. He was identified.
It's the same as the prior one,
Same location.
same location.
Not on liable speaking as well.
Now, what I'm going to do is I'm going to put an ankle monitor on you so I know where you are at all times. You're not to consume alcohol or illegal drugs, and I'm also giving you a curfew. If I find that you're out in the middle of the night, if I find that you go anywhere near this, I'm going to take all your bonds now, and I will triple, quadruple. Do you understand? I'm going to protect my city at all costs. You know, I have 4 open cases. You have made bond on those cases. If they gave you a PR bond, but I'm telling you now, you pick up a good case. I'm going to make your bond so high you'll have. Do you understand? Tell me about the interference, please.
Yes, Judge. So, on November 25th, 2024, an officer reported verbal disturbance in a parking lot while patrolling on foot in an apartment complex. The officer made contact with the defendant and a female. The officer attempted to identify the defendant, who refused to identify himself, stated, "I'm not identifying myself." The officer
Same complex.
please check.
Stop. I don't want you to go within 1,000 feet of this apartment complex. Do you understand? I have a monitor that I'm going to put on your ankle today. If it dings anywhere near there, I don't care what your excuse is. It's not going to go well for you. Your cases are now from November of 24. It is way too much drama for me. So you will get a lawyer today, and in 30 days, discovery complete on the cases from 24. It's way too much drama. I already sent these off the phone.
Is complete on the later.
Very
And
good.
is also complete for the previous promotion.
Get ready. Fast track this trial, 30 days. So I'll appoint him a lawyer today. I'm gonna have him take a seat in the jury box, have him meet with the lawyer. 30 days to get the trial. You're not to consume alcohol, illegal drugs, prescribed controlled medication. I'm going to randomly test you. If I find that you're using, likewise, it won't go well for you. You understand? All right, come on. Good morning, Mr. Wynn. Speak English. Mr. Wynn, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 21st, 2025, an officer was traveling southbound from Frankfurt. The officer was driving 80 miles per hour in the 75-mile zone. He then witnessed someone operating a motor vehicle passing and passed him from the improved shoulder. The officer followed the defendant and witnessed the defendant change lanes when unsafe, drive on the shoulder, follow other vehicles too closely, drive without lights when required, and pass on a no passing zone disregarding the safety of others.
Okay. Mr. Lynn, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run his license, please? You have a license. As a condition of your bond, I'm ordering you not to drive like this anymore. If I find that you do, I will revoke the bond, put you in jail. Do you understand?
His driver's license is eligible.
You're not allowed to drive unless you have valid liability insurance, as well as a Texas driver license. Do you have the ability to hire a lawyer, Mr. Wynn? How old are you? Okay. We'll provide you a lawyer today. You will be signing bond conditions. I'm telling you now, jail sucks. At 18, if you end up going to jail, they will have a field day. You understand? I'm not asking much, but if I find that you make my streets unsafe in any way, it really will not go well for you. Okay. I'll have you sign a receipt and we'll have you. And then we'll. Okay. Deputy Miranda's going to detect you where to go. No, don't worry about it. Do not leave until you sign our bond conditions. Do you mind found? There's no reckless driving, racing, street takeovers, donuts, etc. Good morning, sir. So you're charged with the offense of falsifying drug test results. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be against you. You have the right to have an attorney present. You cannot afford one. And will be appointed to you.
On March 22nd, 2025, the officer was assigned to the Harris County Toll Road Authority, CWI Task Force, observed a vehicle traveling 87 miles per hour at a 65 miles per hour. The officer observed the traffic stop was initiated, and the officer observed a strong odor of marijuana. The defendant stated he personally smoked marijuana earlier that day. The defendant offered to allow the officer to search his vehicle for marijuana. The officer conducted a probable cause search of the vehicle and located a firearm. The officer also found a liquor flask-sized opaque plastic bottle in the glove box, with a temperature sensing strip on the top containing a yellow liquid. The defendant stated he purchased the bottle so that he would not fail a drug test to get a job.
Any open cases?
No open cases, Your Honor.
All right, Mr. Onikidi, I'm going to find that there's sufficient probable cause to go forward with the case. Sir, do you have the ability to hire a lawyer?
Actually, I have a lawyer.
You do have a lawyer. Let me see if any documents have been filled out. Do you guys see anything? Are they going to? You've hired them?
Yeah, I did hire him a couple of days ago.
They told you they would be here?
Something.
Who is it?
He's from Gilligan. Not all right.
Say Gilligan? I guess let's do this. I'm not going to put any conditions on your bond. Well, hold on a second. Does he have a license?
He does. It is eligible.
You're not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. You understand? That is a condition of your bond. I guess I'll have you sign a receipt now. We'll have you take a seat. It's still kind of early. We'll wait to see if they come. If you have a phone number, maybe you can go call them and see if they'll come, and then we can address your. But don't leave until we excuse you. Right? All right.
Judge, that's case law.
Yeah. You are Victor Ortiz.
Yes, Your Honor.
Mr. Ortiz, you're charged with driving while intoxicated. Second offense, facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed.
On March 20th, 2025, an officer observed a vehicle traveling with its rear license plate lamp out, making the license plate unreadable. A traffic stop was initiated. The officer made contact with the defendant, the driver, and the officer observed the strong odor of an alcoholic beverage, watery bloodshot eyes, slurred speech, stumbling, and the defendant used the car for support. During an inventory search of the motor vehicle, the officer located 4 open containers, 2 empty and brown bags pulled to the touch, 1 half empty and 1 freshly opened. All 4 were pulled to the touch and they were 4 logos. The defendant denied drinking the alcoholic beverages and admitted to being an alcoholic, having a drinking problem, but he stated that he did not have any idea how many alcoholic beverages got into the motor vehicle. His offense keys were refused. The defendant was read the GIC and declined to provide a specimen. The defendant was arrested and blood work was signed and executed.
Please, I'm going to find that there's sufficient probable cause to go forward with the case. I am now taking away your privilege to drive. You are not allowed to drive. I don't care what's going on in your life, and you signing an affidavit promising me you're not going to drive. If I find that you do, I can have a contempt hearing. Every time you drive, it's punishable by up to 6 months in jail and a $500 fine. Do you understand? You will now get a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. If you fail to blow into the device, if you consume alcohol, if you consume illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. You understand? If you have a problem, drugs or alcohol, you better address it. Now is the time for you to address it. Because if you don't, it becomes a problem. I will address it for you, and I promise you're not going to like the way that I do it. Do you understand? I am now also placing a restriction on your license that you're not allowed to drive any vehicle that doesn't have an ignition interlock harness. We send this notice to DPS so that everybody in the entire world, or I'm sorry, all officers in Texas know that if you're driving, you must have an interlock, and if you don't, you go to your jail.
Sure.
No alcohol, drugs, random testing, reported advice. You have the ability to hire lawyers, Mr. Ortiz.
My Honor.
have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you. How much money you have at the bank, what you do for a living, what kind of car you drive, and I'll take a look to see whether you qualify. Deputy Miranda's going to give you an application. I'll have you sign a receipt with Victoria. We'll reach out for your bond conditions, and after that, we'll take a look to see whether you qualify. Mr. Smith, you're charged with 2 cases. You're charged with possession of marijuana. You're also charged with unlawful carrying of a weapon. On the gun case, you're facing up to a year in jail and or a $4,000 fine. On the weed case, you're facing up to 6 months in jail and a $2,000 fine. If you are going to do probable cause, you have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 23rd, 2025, an officer had conducted a traffic stop for expired registration at 567 South Mason Road in Harris County. The co-defendant was taken into custody for 5 active warrants. The driver was asked to take the bag with him and take inside the bag. The officer contained a small white plastic bag containing multi-colored plastic pills known to be ecstasy and Xanax. The co-defendant claimed ownership of the pills. A probable cause search was conducted and officers located a handgun with ammunition located behind the driver's seat of the vehicle, a baby bottle containing promethazine cough syrup, and a cylindrical container of marijuana. The total weight of the ecstasy pills was 8.4 grams. The weight of the Xanax pills was 118.2 grams. The weight of the marijuana was 0.05 ounces. The weight of the promethazine cough syrup was 5.19 ounces. The defendant, the passenger in the vehicle, claimed to be the owner of the marijuana and the gun, and stated that the gun fell out of his pocket and landed behind the driver's seat.
Seen it all right. Was there a second gun?
No, there was just one firearm. Yeah.
Did they charge the other gentleman?
Yes.
So how can they charge him with it?
So he took ownership of the marijuana and the firearm. The co-defendant. Yes. The co-defendant took ownership of the ecstasy.
You said that the co-defendant said the gun fell out of his.
No, the defendant said that. Oh, yeah.
All right. Mr. Smith, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with the co-defendant in this case. Do you understand? I'm also ordering you. Can you run his light? He's a driver.
Here's the passenger.
All right. I'm ordering you as a condition of your bond not to be in possession of weapons. Do you understand? Do you have the ability to hire a lawyer, sir? Also. I'll have you fill out an application. I'll take a look to see whether you qualify. I need to know everything about you. Are you working at this time?
Yes, sir.
Okay. I need to know everything about you, and I'll take a look to see whether you qualify. Do not leave until you sign our bond conditions. All right. So no contact with the co-defendant, no weapons.
Here's a key teaching moment. Repeated offenses lead to consequences. The judge revokes the bond to show there are teeth in the system. Think of it as enough is enough. Courts can't just let patterns of behavior slide, especially when community safety is at stake.